one thing we did with these minimum standards is I just didn't write them myself, or you and I just didn't come together and write them ourselves, but we involved the entire firm. Why is that? Well, by the entire firm, all the lawyers at the firm.
Right. So there's a few reasons. One, because one person's ideas aren't as good as 7 or 8 people's ideas. I mean, we can all learn from each other and we can all think about things differently, and those perspectives are important. But also, too, when you're developing some kind of minimum rule that we all have to meet, one, you need it to be realistic. So you want to hear what people have to say about whether they think it's realistic and they think that it's doable. But then two, the more important thing is that you get buy-in from the people that you're giving these rules to. So we've found throughout the years that the more that we have a top-down approach to rulemaking, the harder it is to enforce. But when we have a group making the rules and agreeing to them and having their voice heard, people are more likely to embrace them, more likely to want to meet those standards, and less likely to have excuses. Meeting with the client at the very beginning of the case is really just critical to starting to build the relationship between the lawyer and the client. Also, you get critical information. I mean, oftentimes the lawyer is the only one who knows what questions to ask and how to ask them to get the information that we really need to get the lawsuit on file. It also makes the client just feel so much more comfortable that they've met with their lawyer right away. And so that they have at least a voice if it's over the phone, but hopefully a face to go with their lawyer. So our standard ended up being that within 7 days of the case getting assigned to an attorney team, that an initial client meeting will be scheduled. So the standard that we came up with is within 30 days of the date that we can actually first send discovery. So whatever that date is, depending on what the rule is. So in Texas, it's the day that initial disclosures are due, which are 30 days after the defendant's original answer. In federal court, it's when you do the 26F conference. In Illinois, it's when the court tells you can. And, in different jurisdictions, it's different. And so we wanted, again, to make this apply in every situation. So we said within 30 days of the date that you're allowed to under the rules. And the reason for 30 days as opposed to the day is because we do still want people to be putting thought into the discovery that they're sending out. I think we've talked about it on the podcast before, but looking at the discovery and not just using form discovery is important to us. And thinking about the requests that you're making and making sure that you're being strategic about it really helps move the case forward and is critical to the case. So we wanted to make sure that we weren't encouraging people to just use forms, that we were still giving people time to think about it. It's making sure that we're moving that ball forward to get the deposition scheduled because, the defense has no problem running out the clock. Delay is the friend of the defense. It's not the friend of plaintiffs. And so, if we're not moving the ball forward, they're definitely not. So they don't care about having to ask for continuances, and they don't care about whether or not you miss your expert deadline because you didn't have the evidence you need. This is the way that you are aggressive in a case. But again, these are minimum standards. So we gave ourselves some cushion of time. And we put 45 days here. Again, doesn't mean you can't get it done within the first 7 days if you need to, or if you want to and you're ready. We wanted to make it so that you could apply it in every case.
Absolutely.
What we definitely want our referring attorneys to feel when they send a case our way or that they partner with us on a case is that we're actively working on it and we can tell them exactly what happened. I mean, so if something comes up with a client, we can tell them immediately, and it's not 90 days from now that we say, oh, 90 days ago, this weird thing happened with the client, and they feel like, how did you not know about this for 3 months, And so it's really also about offering service to referring attorneys also, so they feel confident that, we're not letting their important case that they referred to us slip through the cracks. So commandment number 8 is one of my favorite things that we implemented within the last year. Well, now it's been probably like a year and a half. At the firm, and it's a weekly case valuation roundtable that we do. We do it every Tuesday, and we do it at lunchtime. So we have lunch now that we're in the office. We have lunch brought in, and all the lawyers meet and we talk about each other's cases. So any lawyer can present a case at the case valuation roundtable. And the purpose of it is to talk about the case and talk about what we think the value of the case is. We get everybody's opinion, and then the person leaves there knowing, okay, this is what I should send a demand for, and this is my end goal or end game for negotiations. And if I don't get there, I feel confident that we can just go try this case because I've talked to other people about it. So the commandment number 8 is that an attorney must present their case to the weekly roundtable before sending a demand or before just engaging in settlement negotiations. Every time I talk to you about a case, you have some great idea that I never thought of, or you've lived something that I haven't lived, so it didn't occur to me. I was thinking of an example. It was maybe a few years ago, me and you were going to try a case, and I just never had this issue before, but we had a statement that was written in Spanish that was important to the case. And we had a translation of it, of course, but the rules require a specific kind of translation produced a certain amount of time in advance. And we were lucky to catch it like right when we had to produce it. But it never even occurred to me that was a rule or something that we needed to do. And you just happened to mention it offhand to me. And I thought, you know what, we haven't gotten the certified interpreter statement, issued however long it is in advance, 30 days in advance of the trial or whatever the rule is.
I got burned on that.
Right. You've dealt with it before, so and now I know because now I've dealt with it before, but before that, I'd never dealt with it. So it didn't even occur to me to look at that rule, So Michael's experience coming into every single case is so important for our firm and for the success of any trial that we have.